In this video, I wanted to review Monge v. Beebe Rubber Company, which is another agency law case, and this one talks about at-will employment. All right, the facts. The plaintiff, Monge in this case, was hired in September 1968 to work on a conversion machine in the defendant's factory at wages of $1.84 per hour. At trial, the jury awarded the plaintiff $2,500 in damages. You may want to make note of that, as that will come into play later on. The plaintiff, a school teacher in Costa Rica, came to New Hampshire in '65, was attending college at night in order to qualify as a U.S. teacher. Defendant was a union shop, and she joined the union as required. 3 months after that, she applied to work on a press machine for higher wages. However, the foreman told her that if she wanted the job, she would have to be nice to him. She eventually got the job at the higher wages, but then the foreman asked her to go out on a date with him. She refused because she was married with kids. After 3 weeks, the machine was shut down and she was put on a different machine for lower wages. Her overtime was taken away, but no one else's was. Because she needed the overtime, the foreman said she could sweep the floors. She agreed to do this, but the foreman also made her clean the bathrooms while mocking her. On July 23rd, she ran out of boxes for the machine that she was on. The foreman told her to make her own boxes, which she could not do while trying to keep up with production. When she went to complain to her rep, she was ordered back to her machine and then fired at 2 a.m., but later was reinstated with a warning. On July 26th and 27th, Monge called out sick due to an illness. On the night of August the 4th, after being at work for 2+ hours, she was found unconscious in the ladies' room and then taken to the hospital. The company does show her being hospitalized for the next 4 days, but nothing about calling out sick on August 11, 12, or 13. On August 13th, the personnel manager sent her a letter saying that since she failed to report to work for 3 days without notice, that she was deemed a voluntary quit. However, she did call on August 10th to say that she was still sick. In addition, the personnel manager knew about annoying phone calls she was receiving, and he also knew that the foreman used his position to harass female employees, but still asked her not to make any trouble. Okay, so what's the issue? Is the termination of an at-will employee a breach of contract when the employer creates and condones a hostile work environment? What's the rule of law? A termination of an at-will employee when motivated by bad faith, malice, or retaliation is a breach of contract, as it is not in the best interest of the economic system or the public good. So what was the holding in the case? The case was remanded for a new trial unless the plaintiff agreed to a reduction in damages in the amount of $1,083. Reasoning: the court noted that the employer has long ruled the workplace with an iron hand by the prevailing rule that a hiring is presumed to be at will and terminable at any time by either party. The law governing the employer-employee relationship has evolved over the years to reflect changing legal, social, and economic conditions. In all employment contracts, the employer's interest must be balanced against the interest of the employee and the public's interest in balancing the two. The employee has a right to employment stability as long as it does not interfere with the employer's right to discharge and permits him to operate his business efficiently. The jury could draw the inference from the evidence presented that the hostility of the defendant's foreman and complicity of the personnel manager produced the August 13th letter, which effectively discharged the plaintiff. The foreman's overtures and the sudden firing at 2 a.m., the job assignments, and the apparent complicity of the manager support the jury's findings that the firing was maliciously motivated. However, the verdict included damages in the amount of $1,083 for mental suffering, which are generally not recoverable under contract claims. And that concludes the brief. I hope you found it useful. Thank you for watching.